As the year winds down, we look at how well the judiciary has fared. We have the views of a retired judge of the Lagos High Court, Justice Olushola Williams. Also showing on the program, early reactions on the move by the NJC to bar 3 judges from being promoted. Also on the program, we look at issues of high-profile corruption cases in the country, and especially its link with insecurity, plus a recap of the top legal stories on the news. Hello and welcome to Law Weekly on Channels Television. I am Shola Sheyele, and it's good to be back on your screens after a month-long vacation. Now, the year is winding down, but some courts across the country are just holding the ceremonies to kickstart a new legal year. I sat down with retired Justice Olushola Williams to get our views on how well the judiciary has fared this year and what it can do better.
The judiciary has tried to rise up to the challenge. But you know, the Bible says something about putting new wines in old wineskins and they'll burst. Our problem is we try to situate new things, new ideas, without the necessary support, the underlying technology. So you can just have an idea in the air, import it, make a lot of laws, but the implementation is not going to be possible because you don't have the supporting infrastructure. So as a whole, the judiciary has to invest in technological infrastructure. And I'll give a very good example. When Lagos State said it was moving to e-filing, everybody was happy about it, you know. And it looked like the way forward. This was even before COVID anyway, you know, because it just doesn't make sense to have so many people in the registry, so many issues of payment and all. And so we thought it would be nice for people to sit in the comfort of their offices and be able to file their processes. But even before I left in 2019, it was already posing a challenge because you'd have people trying to scan documents. Maybe we had just 2 scanners or 4 scanners, and so there'd be a queue of people. And the thing about court processes is that they're very bulky. When you file, as you well know, when you file a writ of summons, you would not only file the writ, you would file the statement of claim, you'd file the list of witnesses, the depositions of the witnesses, the documents you want to rely on. So you can imagine what a huge, you know, volume of documents you have. Then you try to scan that onto, you know, the system so that it would. So it takes forever to scan. And I remember I was in Ibadan last week. I spoke at the NBA conference, Imo State branch, and the lawyer who comes from Ibadan to file his processes in Lagos was very bitter because Ibadan doesn't have that, you know, they don't say that they've started e-filing on such a good level. But he says it's better for him in Ibadan because he files his documents in the regular way. You go to court. But here in Lagos, when he comes, it takes forever to load the documents to scan and then to get the judge to get the documents. Oh, it has not been brought from the registry. Oh, it is in the e-file, has not been sent to the judge's docket, but we have the physical ones, we can't take it. So it has become more of a nightmare. The whole thing that was supposed to make things easier, and every lawyer in Lagos is complaining. So we need that technological support. We cannot have you know, virtual proceedings in the air. We want to have virtual proceedings. We need the screens. We need staff that are trained with the technology, can set up the virtual proceedings. We need to have IT staff who will make sure that our proceedings don't leak, the security of the documents. So we don't have the infrastructure. So we can just say, because for instance, Lagos State issued practice directions on virtual proceedings. So there's the will, but there's not the means.
When you talk about support, that falls back on the executive.
I didn't want to go there, but we have to. For a long time, you remember that courts were on strike for a very long time because of this issue of financial autonomy for the court. So that's where it takes us back to. As long as the judiciary has to go cap in hand, begging, acting like a parastatal instead of an arm of government that should have its own budget, its own, you know, that's where we're going to be. I respect chief judges. You know, I'm a judge myself and everything, but no legal education qualifies you to be an administrator. Being a judge on the bench for 30 years does not qualify you to be an administrator. We need court administrators. we need people dedicated to administering the courts. There has to be that, break in the functions. So while the CJ does what he does as the head of the court, we also need proper financial administration of the courts. So that person will be able to study infrastructure that has been used in other jurisdictions. But it's too much to ask a CJ to be doing this too. He's going to Abuja today to face NJC. Tomorrow he's going to defend a budget to the House of Assembly. I mean, these are the issues that the court is confronted with. But when we talk about it, I assume it's the judiciary that isn't doing what, but the judiciary is incapacitated.
Now, talking about solutions, I've heard some senior lawyers say that one of the solutions might be that perhaps when the judiciary targets the political class, especially on issues arising from the 2023 election cases, that we might actually start to see results.
I'd even say it doesn't have to get to that. I think that it's a bit unfortunate when everybody suffers, and then when it is a case that you call high profile, political, then everybody rushes around like headless chickens. No, let them go through the process like everybody else. It's not even a question of targeting. If it takes every case 10 years to be heard, let a political case be heard within 10 years as well. So why are we making special dispensations for political cases? Are the murder and the rape cases not important as well? So you hear people saying, oh, you shut down every other case that you're doing because you have what is called a high profile case.
Another issue confronting the judiciary is that we've seen a lot of instances where courts of coordinate or concurrent jurisdiction are giving different judgments on same cases, same parties, same facts. And the Chief Justice of Nigeria has had cause to call out some judges on this issue. And a lot of people think that this may get worse as we approach the election season. But talking about solutions, how do you think that we can deal with this issue?
Okay, so the Chief Justice of the Federation called some judges to order, called them out. So that's him doing what he can do with judges. That's him, so that, how about the lawyers that filed the cases? How about the litigants whose names are on the processes? The court doesn't have any authority over those. What is the Bar Association doing? A judge doesn't just wake up and say, I want to grant an injunction. No, it doesn't happen. Somebody has to apply. Somebody deposed to affidavits that hid the truth or misrepresented the truth. Those people have to be dealt with. So there are many people with their fingers in the pie. So you don't just look at the judges. Yes, judges ought to read processes well. And don't forget what I said about technological infrastructure. Perhaps if we had a good data system, once you sue and you have the same sort of cases, there should be a flag, a red flag from the system saying, oh, this sort of case has come before. But we don't have what we need, the technology.
Now let's get a little bit more personal. About 3 weeks ago, the legal community, especially in Lagos, came out in honor of the 9th Chief Judge of Lagos, your father, the late Justice Samuel Laurie, who passed away on October 12. He was widely described as a reformer and is credited as the pacesetter who introduced verbatim court recording machines to enhance efficient justice delivery in Lagos. It seemed that at that time he was very forward-thinking.
I always say that he made me fall in love with the law because he was so in love with it. And one of the statements he said, and I'm sure I've said it before, was that he said, a lawyer is an all-rounder. That when a lawyer is taking up the case of an accountant, he becomes an accountant in order to be able to defend the accountant better than the accountant himself, and so on for every other profession. And that is why we are called learned. But more than that, he loved justice. So we talk about him introducing verbatim reporting. In my tribute to him, I also remember the fact that he was one that, because he wanted speedy dispensation of justice, and he had worked as a solicitor general, so he had worked as a criminal lawyer. He knew the plight of people awaiting trial, and he had this system. He then said that there should be magistrate courts in every prison, so that all the issue of moving people in custody around, or some urgency, so that you will be able to move faster if you have the magistrate court in the prison. And that is what he did. And then he was the first chief judge that said, oh, I can't do this all by myself. I need judges that are next to me in rank to help. So he started this admin judge, so that an administrative judge for each division, because we have two broad divisions, Ikeja and Lagos, so that apart from the chief judges at the helm, they had admin judges who would help to administer each division. Yes, he was the one that actually started that, and of course it has become a culture in Lagos. So that showed, his, like you said, foresight as an administrator.
So as part of lessons for the legal community and everybody generally, what do you think that we can learn from his life and time?
He was always available to help and to work. I asked him to be on the advisory board of this institute, and he was very happy to do it, and he would always give advice. When we were trying to review the rules of court, he was there. He was a retired judge. He could stay at home, but he attended all the meetings. In fact, we started calling him the father of the new rules, because he also loved procedure. And he believed that if you don't get the procedure right, you can't even begin to move into justice. And that's one thing I want people to learn, that you need to understand access to justice. And access to justice is more than what we've talked about, the infrastructure thing. Even what the lawyer himself does. If you don't get your procedure right, you can't even begin to deliver the goods. And I'll give you an example. I have to go back there, having paralegals.
Yes, I was going to round up with that.
I have to go back there because maybe people don't understand that paralegals, having properly trained, professionally trained paralegals, also affects access to justice. Because if the judges are burdened doing, routine legal work, and the lawyers too are doing routine legal work, they're able to take on less matters. So if a judge is busy correcting his judgments, spending 2 hours doing preliminary work, he's going to have less time to do the core work. That is why we need trained paralegals. They improve access to justice. That's part of. So that's why I said there are many players in the issue of access to justice that we don't even realize.
I'm happy that you brought up the issue of paralegals, because this has always been your passion, so much so that you took an early retirement from the bench to set up the Institute of Paralegals. How would you describe the reaction of the legal community to paralegals? Because I know I've seen some of your trainings and all.
Like every new thing, mixed views. A lot of people have mental assent, but to translate the mental assent into action has been. But I can tell you, when I think of, we've had COVID, we've had economic downturn, we've had strikes and everything, I say that Nigerians are really ready to move forward, because in spite of all that, we were supposed to do graduation, and we have 35 people that we wanted to give certificates to who had done the whole training, because we have different aspects. So yes, a lot of law firms are keying into it because we have no choice. If we're going to have global partnerships, lawyers and lawyers will talk, and paralegals have to. So if we don't have trained paralegals, it's going to show up. So all those foreign companies, all those foreign legal firms we want to work with are not going to be able to deal with us, with our untrained paralegals. So yes, I think people are realizing it. So I would say that there's still people who fear that, you will displace lawyers won't have a lot of jobs. But it's actually going to raise the bar in the standard of practice, and we have to be prepared for it.
Away from that interview, lawyers have been reacting to the news of the National Judicial Council NJC's resolve that 3 judges who granted conflicting ex parte orders in matters with same parties and same subject matter will be barred from higher bench for a period ranging from 2 to 5 years whenever they are due.
We will not be talking about adequacy of the disciplinary measure, but the most important thing is that there has been disciplinary measures now meted out to just judges. I think that everyone now will be very careful in issuance of conflicting ex parte orders. We know the reason why ex parte orders are given is usually to preserve the rest, but most times these things are done now in political cases. Now for MBA also really frowned at some of our colleagues who actually initiated some of these processes that led to this issuance of conflicting court orders. We took time to ask for those processes, and we got them. And then we examined the content and the process and procedure that were adopted by some of our colleagues, and we felt that there were certain things that were clearly a breach of some of the ethics. So what we did was to do a comprehensive report and recommendation to the president of the Nigerian Bar Association, and it's obvious that the president has gone through that report and presented it to NEC that just ended in Abeokuta. And then the import is that NEC ratified the decision that some of our colleagues that were involved should be referred to the LPDC.
I am very concerned about the decision of the NJC. I think it's a slap on the wrist for the judges that they have they've adjudged to have compromised their position as judges by allowing those expertise orders to go through. Aside from those judges, even the chief judges of those respective states that assigned those cases need to be reprimanded. Aside from that, those judges who made those decisions should be removed from the bench immediately. I'm also worried about the punishment for the lawyers. Nobody has really said anything about it except for the Nigerian Bar Association NEC meeting said they should be referred to the LPDC. And I think that the LPDC does not have enough teeth to ensure that those lawyers are reprimanded. I think those lawyers should be derobed, if anything at all, or be suspended for practice.
Now, the Imo State Governor, Opus Odima, has given assent to the Violence Against Persons Prohibition VAP bill aimed at checkmating sexual and gender-based violence in the society. Speaking after signing the bill into law at the executive chambers in Owerri, the Imo State capital, Governor Odima says his administration will continue to support and implement policies and programs that will improve on the human rights of the people.
This is the first bill to be passed into law since the new Speaker of the Imo State House of Assembly, Kennedy Ibe, emerged, and he's here at the executive chambers in Imo State with other members of the State House of Assembly to witness the signing into law of the Violence Against Persons Prohibition Bill. The Speaker gives a quick rundown of the importance of the VAP bill, urging Imo indigents to take advantage of the passage of the bill to eliminate all forms of sexual and gender-based violence.
The bill is designed to tackle all forms of violence against persons in private and public life and provide maximum protection and effective remedies for victims and punishments for offenders.
Then the Governor puts pen to paper. In his speech, the Governor reiterates that the bill doesn't support same-sex marriage and abortion, but rather it tackles all sorts of violence against persons, especially sexual and gender-based violence.
There is no area, no aspect of this bill that is violating our tradition, our customs, or even our Christian faith.
A major advocate for the signing of this bill, the wife of the Imo State Governor, Chioma Uzodimma, who was present during the signing ceremony, is grateful to the government for the new feat, which she believes will go a long way in safeguarding the rights of women, girls, boys, and men in Imo State.
We're going to work on a SAC center, which is a shelter for assaulted or women and girls who have had any of these issues, so, and then we're going to have a sexual offender register.
With this development, Imo State is now the 19th state in the Federation to domesticate the Violence Against Persons Prohibition Bill.
Now, did you know that a large number of Nigeria's high-profile corruption cases are derived from security votes? Well, a former prosecutor with the Economic and Financial Crimes Commission, Senior Advocate of Nigeria, Rotimi Jacobs, disclosed this at an event held recently in Lagos. But going forward, the federal government is set to adopt a non-conviction-based forfeiture regime focused on confiscating proceeds of crime. We have details on that in this report because these were the issues which formed the basis of discussions at an event to mark the International Anti-Corruption Day. Senior lawyers, activists, as well as members of different civil society organizations are gathered here in Lagos at the instance of a non-governmental organization, the Human and Environmental Development Agenda Header Resource Center. The center has done some investigative research and analysis to update its annual compendium to provide members of the public with verifiable information on some protracted 100 high-profile corruption cases that began since 2005. The aim, among other things, is to challenge the administration of criminal justice system in Nigeria on the need for reforms and speedy dispensation of justice.
It is now a normal standard that an average high-profile corruption cases involving politically exposed persons must actually take nothing less than 10 years for you to even get through at the first court of instance.
The Executive Secretary, Presidential Advisory Committee Against Corruption, Professor Sadiq Rada, fingers lawyers and judges as major clogs in the fight against corruption. He says that they have long turned the fight into a business venture, but a senior advocate of Nigeria says the judiciary cannot entirely take the blame.
If our lawyers and our judges will manipulate AJA, which says certain things should be done. I don't know them, I'm not a lawyer. But AJA is meant to speed the process of trial in Nigeria. But the same lawyers who brought it about, the same judges who brought it about, are the ones circumventing it. So we need to get it right. It's beneficial to have a sound judiciary.
To blame the judiciary or to blame lawyers for the delays that have been noted in the prosecution of corruption cases will just be telling, a little bit, of the story. Let us also beam our searchlight on the prosecuting agencies. In my own experience, they are the ones that come to court asking for adjournment.
Another senior advocate of Nigeria, a leading prosecutor with the Economic and Financial Crimes Commission, EFCC, Mr. Rotimi Jacobs, says the majority of corruption cases in the country can be traced to the mismanagement of security votes.
During election, the security vote will balloon the last 3 months to the election. In some states, 5 billion. In some states, 3 billion. And cash are being given to the governors, not to spend on security, but for election in all the state of the federation. Now, why is it that e-payment, why is it that the government, if they are sincere with the fight against corruption, are not employing this method of e-payment for all payments being done by the government? The major problem we have, if we are serious with fight against corruption, the cash transaction in government must stop.
Other senior lawyers give suggestions for tackling corruption.
But our electoral system is so warped that to me it does not appear to be capable of bringing out any credible leadership. Once we cannot have a credible leader, forget about good governance, and corruption will continue to flourish.
If the economy do not grow, there's really nothing you can do about this, about fight against corruption. That means we are just addressing the effect and not the causes.
Meanwhile, the Executive Secretary of PACAC says going forward, the federal government will adopt a non-conviction-based forfeiture regime.
The EFCC, ICPC, all this, and they will not go after individuals now. They will go after your property. They will confiscate the property. If it is yours, come forward and explain how you got it. ICPC has started. Today we have as many as 240 to 300 shops, malls, plazas that have been taken over. Today EFCC is in control of over 90 ships, and the owners have disappeared.
Let's now take a recap of some of the top stories from the courts.
We begin with the report that the police has arraigned 15 persons who were allegedly involved in the siege on the official residence of a Supreme Court judge, Justice Mary Odili. They pleaded not guilty to the 18-count charge bordering on conspiracy, threat to life, forgery, unlawful forced entry, and attempts to execute unlawful search warrants. Justice Nkoyema had granted bail to 12 of the suspects and adjourned further proceedings to January 17, 2022. In Lagos, the Special Offences Court sitting in Ikeja has granted bail to the former Minister of Aviation, Femi Fani-Kayode, in the sum of 5 million naira. Justice Olubunmi Abike-Fadipe granted him bail after ruling on an application by the former minister challenging the jurisdiction of the court to try him on the charge of forgery and procurement of a fabricated medical report made against him by the Economic and Financial Crimes Commission, EFCC. And the chairman of the Economic and Financial Crimes Commission, Abdulrasheed Bawa, has again continued his testimony in the charge of forgery and subsidy fraud made against one Abubakar Ali Peters and his company, Nadabo Energy Limited. The defendants are standing trial at the Lagos High Court sitting in Ikeja on a 21-count charge for offences bordering on obtaining money under false pretense, diversion of federal government funds, and forgery to the tune of 761 million naira. Justice Sedoten Ogusaya had adjourned further proceedings to February the 17th and 18th, 2022. From the High Court, we move to the Federal High Court, also in Lagos. The court has perpetually restrained the federal government, through the Minister of Interior, from further contracting marriages under the Marriage Act 2004 within 4 local government council areas in 4 states. Justice Daniel Osaigo also granted in part a relief seeking the sealing of all federal marriage registries in their local governments. The court, however, exempted marriages conducted in the marriage registries of Ikoyi, Lagos, and the Federal Capital Territory, Abuja.
That's the show. Thank you for watching. Please catch up with past episodes on our YouTube page. I am Shola Sheyele. See you next week.